I'm a right kind of person.
All day. Jason, does he know about the slides? Boo! Thank you.
I'm really glad. I'm really glad you're not a signer. So.
You knew what I meant, though. So.
I work for you too long.
You don't work for me.
I work with you too long.
Yeah. No, you can't go back. We do not interact with that department.
Hi everyone, we're going to get started. I just wanted to welcome everyone to the Great Arts Institute Inaugural Constitutional Address. I'm Carol McNamara. I'm Carol McNamara, and I'm the director of the Great Arts Institute and this is our inaugural Constitution Address. I want to begin by thanking our host, Veritas Prep, and for engaging with us and helping us get the message out about the event tonight. I also want to thank Headmaster Wayland for offering the venue to us and for bringing in her community. I would like to thank the Jack Miller Center and the Jack Miller Center on Advancing America's Founding Principles and History, who offered their financial support and sponsorship for the event, and so I'm very grateful to them for their support. They also sent us a whole box full of pocket constitutions, and you can pick one up either on your way, maybe you got one on your way in, or you can pick one up on the way out. Before I introduce the program tonight, I just wanted to take a minute to explain why it's important that we celebrate the Constitution and rededicate ourselves to its perpetuation each year. Why do we celebrate Constitution Day? What's the point? And what does it have to do with the classical education Great Arts students pursue with their teachers every day? Constitution Day, of course, honors the day, September 17th, which was yesterday, that the delegates to the Constitutional Convention met for the final time to sign the document they had written and which they were about to send to the states for ratification. And then Congress, first in 1952, and then in 1956, created Constitution Day and then Constitution Week. And finally, in 2005, Congress consolidated different laws to create Constitution Day, the official day, September 17th, to require states and counties and cities and towns and educational institutions to commemorate the Constitution. Why is it important for citizens to celebrate Constitution Day? The official purpose of Constitution Day is to set aside a day for civic instruction regarding the responsibilities and opportunities of citizens of the United States. Constitution Day provides an opportunity for Americans to reflect on the unique nature of the represents a great experiment. As Alexander Hamilton tells us in the first of the Federalist Papers, where he poses the question whether society, quote, and I quote, societies of men are societies of men really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force. Hamilton is asking whether human beings were capable of designing a government to the people who would govern themselves, all with the purpose of protecting their rights and freedoms, and to ensure that the states live together peacefully in a more perfect union. We're over 200 years into that experiment. So far, so good, you could say. And of course, next year, 2026, we'll celebrate the 250th anniversary of the Declaration of Independence. But it's important to remember that while the United States enjoys a stable democratic Republican government, political liberty is always fragile and requires study and attentiveness for it to endure. I just wanted, so every year we commemorate the Constitution, and that's why in classes at Great Hearts and in Great Hearts classes here at Veritas and across Arizona and Texas and Louisiana, we study the Federalist Papers, we study the founding, we study the founding principles, and we continue to think about the fragility and the importance of our Constitution and why it's important for us to continue to study it and think about it in order to perpetuate it. Okay, let me begin first by introducing our moderator. Brandon Crowe is the Superintendent and Managing Director of Great Hearts, Arizona. Superintendent Crowe joined Great Hearts in 2007 as a humane letters teacher here at Great Hearts Veritas Prep, where he taught for 5 years and held several leadership positions before he moved to Glendale Prep for 6 years, before moving to an executive leadership role with Great Hearts, Arizona. He is a member of the Arizona Charter School Association Board of Directors and holds an MA and BA in Religious Studies from Arizona State University. And let me just add my own words of appreciation for the partnership and support of Superintendent Crowe and his Arizona team to the Great Hearts Institute and our annual national symposium, as well as this Constitution Day. I just wanted, so there are cards and information about our national symposium that we hold each year, so please take the information. We have a great keynote lecturer, Matthew Crawford, who is the author of the New York Times bestseller, Shop, Class, and Soulcraft. I always get that wrong, so there you go. Thank you. We have some, I know, I'm terrible.
People of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
Thanks so much, Dr. McNamara. I have the honor to get to introduce our speaker here in just a moment, but thank you for coming out. Like Dr. McNamara said, this is a work that we're just kicking off this year. We know that it'll bear a lot of fruit, hopefully for you all, certainly for you all, and then definitely in years to come. So we're just so excited and grateful for your presence, and especially for Dr. Porwancher here, especially because being in Phoenix, we get to be connected to Arizona State University, but specifically to SCEL, the School for Civic and Economic Thought and Leadership, where Professor Porwancher is the Director of Graduate Studies. But this has been a beautiful thing, a virtuous circle, where we have students who will go on to graduate and can find a place nearby to study and engage. We have faculty who can continue with their learning, graduate degrees and programs, and then also can benefit from all the wisdom that's there too, and then sometimes their own graduates come to teach with us. So it's been a real blessing, and today is just another indication of that. So really fortunate here to be able to be together tonight and get to tell you a little bit about our speaker here. So a native of Princeton, New Jersey, Andrew Porwancher earned degrees from Brown and Northwestern before completing his PhD at Cambridge. At the aforementioned Skettle, he serves as professor and director of graduate studies. He is the author of The Jewish World of Alexander Hamilton, which was published in 2021. And though the topic is a bit different, I'll tell you, a phenomenal book. I commend it to you in our symposium just last year. Professor Porwancher gave a talk on it. It was fantastic. And so this isn't the only thing you can learn from his good work. This book, The Jewish World of Alexander Hamilton, was the winner of the Journal of the American Revolution Book of the Year Award and Independent Publisher Book Award. Professor Porwancher previously served as the May Fellow at Harvard, the Horn Fellow at Oxford, and the Garwood Fellow at Princeton. In 2017, he won the Longmire Prize for Innovative Teaching, and now he is at work on his fifth book, Theodore Roosevelt and the Jews, forthcoming from Princeton University Press. His other books include The Devil Himself, from Oxford University Press in 2016, and this is actually adapted for the stage in Dublin. And so Dr. Porwancher's writing has appeared in the Washington Post and the Wall Street Journal, and prior to coming to ASU, he spent 12 years at the University of Oklahoma. So let's welcome.
Thank you so much. Thank you for that introduction. I want to thank, in particular, Dr. McNamara for the invitation. I'm grateful to the superintendent, to the headmaster, and everybody who helps an event like this, from the folks checking in to the audio-visual. There's a lot of legwork that goes on. And I'm especially grateful to the Jack Miller Center, an organization I've been connected to for the last 13 years, for helping make today possible. I want to thank all of you for lending us an hour or so of your evening tonight. All too often today, the Constitution is wielded as a weapon, breathlessly invoked by one partisan side or the other in service of some narrow political objective, often with limited curiosity about its history or even the actual text of the document. Today, I want to return to the Constitution, to its framers, and ultimately to its lessons for us today. And by recovering that history, we will find that many of our commonplace assumptions about the Constitution are myths that need to be debunked, and hidden truths will be revealed. So let us turn the clock back to the summer of 1787, when the delegates convened here in the Pennsylvania State House on Chestnut Street, where we know today as Independence Hall. You know, we often make a mistake when we think about history. It's a subconscious error. We don't realize we're doing it on some level. We assume that historical figures knew how their future would play out, that when the delegates came together in Philadelphia, they knew with confidence that they were embarking on an experiment that was sure to endure in perpetuity. But the truth is that their knowledge of their future was as impoverished as our own. Just as we are constantly buffeted about by unexpected current events, so too were they. And from the vantage point of 1787, it was not at all clear that America would survive much longer as a nation. At that time, we were governed by the Articles of Confederation, and the Articles were failing. Under the Articles, there was no judiciary branch that could adjudicate disputes between citizens of different states. There was no executive branch to enforce the laws. It was more of a league of loosely connected mini-countries. In order to pass any legislation under the Articles of Confederation, you needed total unanimity across the states, and tiny Rhode Island kept unilaterally sinking endeavors that were otherwise uniformly supported by the rest of the country. And this kind of political disorder soon led to violence, notoriously in Shays' Rebellion, starting in late 1786, when a ragtag militia of farmers in western Pennsylvania took up arms against the state. And the federal government proved wholly impotent in suppressing the insurrection. Ultimately, a mercenary army
had to do the work. And so from the vantage point of the delegates in the summer of 1787, the Constitutional Convention looked perhaps less like a surefire start of a legal charter that would last for centuries to come, and more of a last-ditch, 11th-hour bid to salvage a republic that seemed perhaps at the risk of dying in its very infancy. And so with that sense of the framers' perspective, their limited perspective, as we all have about our futures, that palpable sense of contingency of history, let us turn to the work of debunking some of the enduring myths that continue to cloud our understanding of this document. So myth number one, we are supposed to have 3 co-equal branches of government. The idea of co-equality of branches is an article of faith. You can find it referred to in many judicial decisions from the federal bench. And it's wrong. It's historically inaccurate. The founders did not want 3 co-equal branches. To be sure, they instituted a system of checks and balances to ensure that no one branch would dominate the others. But that doesn't mean that they wanted all of the branches to stand upon a perfect equality. And to make my case for debunking this myth, I want to turn to the Federalist Papers. And in case anybody here might be joining us from the broader community and maybe is more than a semester or year removed from their most recent civics class, I'll just briefly give you a very short synopsis on the Federalist Papers. On September 17th, 1787, the delegates signed their names, as Dr. McNamara mentioned, to the Constitution. It's just ink on parchment. It had no legal force. Only if at least 9 of the 13 states ratified the Constitution would it take legal effect, and even then, only in the states that actually ratified. And so Alexander Hamilton, John Jay, and James Madison team up, writing under a shared pseudonym, Publius. They produce a series of 85 essays designed to rally New Yorkers specifically to send pro-Constitution delegates to New York State ratifying convention. Why New York? Well, New York was particularly important. People in Virginia will tell you how important Virginia was, and it was very important. But New York was central to the Union geographically, commercially, politically, and support for the Constitution was deeply contentious in that state. So it was essential to rally people to send pro-Constitution delegates to that ratifying convention. And the Federalist Papers, which are a kind of exegesis of the constitutional text, are some of the most important sources we have for interpreting the document. So what might the Federalist Papers have to tell us about the notion of co-equality between the branches? Where here is James Madison in Federalist 51. He writes, in Republican government, the legislative authority necessarily predominates. So we have Congress, according to him, as the most important branch of government. And here's Alexander Hamilton in Federalist 78. The judiciary is beyond comparison the weakest of the 3 departments of power. So if we have Congress as the most important and the judiciary is the weakest, we have the presidency in the middle, right? And we can see this idea reflected in the text of the Constitution, right? The Constitution invests Congress with the power of the purse. They make the president the commander-in-chief, but the judiciary has no similar tools at its disposal to enforce its own opinions. If we look at the text of the document, the very first article is about Congress. The second article is about the executive branch, and the third article about the judiciary. And indeed, the longest of those 3 is about Congress, then the presidency, and by far the shortest is Article 3 concerning the courts. None of this is coincidental. Why would the framers want 3 unequal branches of government? Well, we have to look back to their experience as British subjects under colonial rule. During the era of British rule, the governors of the colonies were selected by the crown, and the judges were selected by those governors. So both the judiciary and the executive were functionally extensions of royal power. But in the colonial era, the local legislatures, the assemblies, they were selected by the local colonists. And so Americans had been primed through 150 years of British colonial rule to see legislatures as uniquely representative of their interests and their liberties. And so it should be little surprise to us that they would invest Congress with the lion's share of power. And one of the extraordinary developments, from my perspective as a constitutional historian, over the last couple hundred years, and I'm not telling you how to feel about this. You can like this or not. That's your prerogative. I'm just the messenger here telling you what the history was. The scope of judicial and executive authority has grown far beyond what the framers initially envisioned. So that's myth number one. Let's turn to myth number two, which is that the rights in the First Amendment, freedom of speech, freedom of press, freedom of religion, these are in the First Amendment because they are our first and foremost rights. Almost every year, some law professor will come out with a book that's entitled something like First Freedoms, Church and State, or First Freedoms, Freedom of Speech. The truth is that the rights that we know in the First Amendment today were actually initially in the Third Amendment. And they only became part of the First Amendment by default because the first two amendments to the original Bill of Rights didn't get ratified. The real First Amendment was an algorithm for determining the size of congressional districts. And the original Second Amendment had nothing to do with guns. That amendment specified the conditions under which members of Congress could vote to increase their own salaries. Wasn't ratified. And so the Third Amendment bumps up to the first. And so it's a nice little rhetorical flourish to call these freedoms our first freedoms, and they are our paramount freedoms. I don't gainsay that. But it is an accident of history that they wound up in what we know today as the First Amendment. So let's delve deeper into the text of the First Amendment to debunk yet another myth. If you ask most Americans, many of them polled on the street will tell you that the phrase separation of church and state appears in the text of the U.S. Constitution. In fact, it does not. This is the language that we have. Congress shall make no law respecting an establishment of religion. So where does this language of separation of church and state come from? And how is it that it came to be conflated with the Establishment Clause? Well, to answer that question, I have to tell you the story of the so-called Mammoth cheese. On New Year's Day in 1802, Thomas Jefferson, then sitting as president, receives at the White House a massive wheel of cheese. I know you're thinking, Porwancher, I've seen some pretty big pieces of cheese. I don't think you've seen a piece of cheese like this. It was 17 feet in circumference. It weighed over 1,200 pounds, and emblazoned on its crust were the words, "Rebellion to tyrants is obedience to God." So a local poet publishes a poem at that time in the newspaper about the mammoth cheese. And he writes, "But muse, you'll not forget to squeeze a word about the mammoth cheese. Such cheese no man before set face on. 'Tis bigger than Don Quixote's bason. Such cheese, my stars, 'twould make one swoon. To view 'tis bigger than the moon. This cheese is surely honored more than ever any cheese before. To feel the weight and force, forsooth, and crash of presidential tooth. Ye maggots that dwell in the cheese, with horror how your limbs will freeze, how you will kick and squirm and claw beneath the Jeffersonian jaw." Now, what does a massive wheel of cheese have to do with constitutional history? Everything. The cheese was a gift from a preacher to thank Jefferson for his commitment to religious liberty. Now, Jefferson at that time had received a letter a few months prior from the Baptists in Danbury, Connecticut, complaining that the state government was discriminating against them relative to other religious denominations. And he hadn't written them back. But when he gets this massive wheel of cheese, inspired by the mammoth cheese and all that it represents, Jefferson is moved to put pen to paper, and he writes a letter back to the Danbury Baptists that forever changes the course of American constitutional history. And here is what Jefferson writes: "I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. This is where we get the language of separation of church and state from Jefferson, writing nearly 15 years after the Constitutional Convention. So when Jefferson says that the Establishment Clause mandates a separation of church and state, is he speaking for his generation, or is Jefferson doing what politicians sometimes do, which is to conveniently see in the text of the Constitution, happily, a mirror of their own personal political preferences? Well, to be sure, Jefferson was not alone in advocating for the separation of church and state. James Madison adopts very similar views. There are yet others. But that was just one of multiple competing schools of thought at that time. And to find an alternative vision of church-state relations, we need look no further than the father of the country, George Washington. Now, Washington was as fervently committed to religious pluralism as any of the founders, but he also believed that government and religion could nurture a mutual bond. So what does the Washingtonian principle look like in practice? Well, if you go back to the 1780s, even before the Establishment Clause, Washington articulates just such a perspective when the state of Virginia, his home state, was considering the passage of a bill that would require people to lend their tax dollars to Christian schools. And Washington writes, "I am not amongst the number of those who were so much alarmed at the thoughts of making people pay towards the support of that which they profess, if of the denomination of Christians." And here the language is crucial. "Or declare themselves Jews, Mohammedans," meaning Muslims, "or otherwise, and thereby obtain proper relief." In other words, non-Christians would be exempt from this tax. And so we see here Washington wedding the principle of respect for minority faiths with the idea that government and religion could be mutually supportive. And Washington isn't alone in these views. Alexander Hamilton also advances the idea that government and religion should work toward common ends. In 1796, as Washington is preparing to step down as our nation's first president, he tasks Alexander Hamilton with ghostwriting his farewell address. And Hamilton drafts a paragraph that many scholars consider to be Washington's single most important statement on the relationship between politics and faith. And it's not just Hamilton's words. Washington gives him edits. They go back and forth with multiple drafts. And here's what they come up with collectively in the famous farewell address. "Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports. In vain would that man claim the tribute of patriotism who should labor to subvert these great pillars of human happiness. And let us with caution indulge the supposition that morality can be maintained without religion. Reason and experience both forbid us to expect that national morality can prevail in exclusion of religious principle." You would be hard-pressed to find the likes of a Jefferson or a Madison articulating a sentiment like this. And what's really interesting is that as you move forward into the 19th century, by the mid-19th century, the people who pick up the Jeffersonian mantle of separation of church and state aren't those who have the most compassion for minority faiths. It's actually the people who are the most anti-Catholic. So during that time, America is rapidly industrializing, and many Catholic immigrants from places like Ireland and Germany are pouring into the country to take up these new industrial jobs. And there is some faction of native-born Protestants, not everybody, but there is a faction that feared that these Catholic immigrants were the front lines of a papal invasion, that they would be loyal to the Vatican over and above their adopted homeland of America. And so these Protestants start championing the separation of church and state in a bid to keep the Catholics in check, for fear that the Catholics would seize the levers of state power and make America some sort of province of the Pope. And so the separation of church and state, it becomes this reactionary, anti-Catholic, xenophobic ideal. And only later in the 20th century does it get recast as this secular ideal. And it happens in a landmark Supreme Court decision called Everson versus Board of Ed. And here is Justice Hugo Black interpreting the Establishment Clause. He says, in the words of Jefferson, The clause against establishment of religion by law was intended to erect a wall of separation between church and state. That wall must be kept high and impregnable. We could not approve the slightest breach. So, in this Supreme Court decision, Hugo Black takes Jefferson's letter, written 15 years after the Constitutional Convention. He takes this language from the letter to the Danbury Baptist and he elevates it to constitutional status. Hugo Black writes out of the history the diversity of opinion among the founders on church-state relations. And it's also a little bit curious that he picks Jefferson, of all people, to be the sole arbiter of the meaning of the Establishment Clause, because Jefferson was highly idiosyncratic when it came to religion. He rejected the idea that Jesus was the Son of God. It's not a mainstream Christian belief. He was deeply anti-clerical. He thought much of the Bible didn't happen, crossed out the parts of the Bible that he rejected, and retitles it The Life and Morals of Jesus of Nazareth. He is an odd choice to be taken as the sole spokesperson for the founding generation when it comes to religion and politics. Now, I am not here arguing today in favor or against the separation of church and state, or in favor or against any other position. That's up for all of us to decide as citizens. But I am here as a historian to say that if we're going to have our jurisprudence premised on history, it has to be done on a faithful reading of the historical record that is alive to that record's nuances and complexities, instead of cherry-picking evidence to support some sort of predetermined legal conclusion. So, moving on to the next myth. We're making good progress. The next myth is that the Free Exercise Clause is the most important clause for protecting religious freedom in the Constitution. And I would argue that that's actually wrong. That there is a different clause, lesser known, buried in the text of the Constitution that is far more important for protecting religious liberty. And it's found here in Article 6, Section 3. No religious test shall ever be required as a qualification to any office or public trust under the United States. Well, why would a clause that only pertains to that small sliver of people seeking federal office be more important than the Free Exercise Clause, which applies to everybody? Well, to answer that question, we have to look at the original state constitutions. When the American Revolution begins, the colonies are no longer colonies, they're self-governing states, so they go about drafting state constitutions for themselves. And many of them have something akin to the Free Exercise Clause that prefigures what we'll later see in the Bill of Rights. So in 1776 in Pennsylvania, they ratify a constitution that reads, "No authority shall in any case interfere with or in any manner control the right of conscience in the free exercise of worship." But that same state constitution introduced a exclusionary oath of office for the state legislature, which required the following words: "Each member, before he takes his seat, shall make and subscribe to the following declaration. I do acknowledge the scriptures of the Old and New Testament to be given by divine inspiration." Which begs the question, how free is the exercise of one's faith if you have a civil disability imposed on you for exercising your religion? And so you might be thinking, well, maybe that's just Pennsylvania. Do you have any other swing states? Let's go to Georgia. "All persons whatsoever shall have the free exercise of their religion," right? That's all well and good. What does Georgia have to tell us about the eligibility for the state legislature? "The representative shall be chosen out of the residents in each county, and they shall be of the Protestant religion." So it walls out Jews and Catholics. And you might be thinking, okay, well, those are the swing states. How about a non-swing state? Well, let's go up to New York. "The free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever hereafter be allowed." And yet that same state constitution required that Catholic immigrants forswear their allegiance to the Pope, not just in a political sense, but in an ecclesiastical sense as well. And New York had blue laws that forbade work on Sunday. So if you were Jewish, you couldn't work on Saturday because of your faith or on Sunday because of state law, meaning you could work 52 fewer days a year, about more than 7 weeks worth of lost income. You were functionally paying a tax for being Jewish. One particularly enlightened assemblyman in the New York State legislature tried to rally his fellow delegates against the blue law. He said, "This was not equal liberty, one of the boasted blessings of our government." But his appeal fell on deaf ears. And so it is against that backdrop that we see that abstract promises of religious liberty might actually mean very little if they're not followed up with concrete grants of equality. But in the U.S. Constitution, they take the radical step at the convention of banning religious tests of any kind for office, appointed or elected. It is a remarkable advance in the history of religious liberty. Now, it should come perhaps as little surprise that when the delegates reveal their work, which had been kept secret over the summer, and the Constitution gets sent out to the states for ratification, opponents of the Constitution, which were dubbed anti-federalists, tried to scaremonger people about the ban on religious tests. And one delegate at the Massachusetts ratifying convention said, "A Turk, a Jew, a Roman Catholic, and what is worse than all, a universalist, may be president of the United States." But despite these voices of intolerance, the voices of enlightenment carried the day, and the Constitution, including its revolutionary ban on religious tests, was made the law of the land as it still is today. We often think about the Constitution. We read the Constitution in light of our modern day political controversies, naturally so. And of course, we want the Constitution to solve our problems, to give us clear guidance, to answer our questions for us. That I would submit to you that the point of the Constitution isn't to resolve our debates. It is to establish legislative halls and courts of law where these debates can proceed peacefully. What the founders understood is that when debate ends, violence begins. That when people stop yelling at one another, they start firing at each other. The Constitution that they bequeathed to us was crafted in an era whose politics were as fractured and toxic as our own. And so they crafted a Constitution where we can continue to have legal, peaceful disagreements, because the alternative is bloodshed. The founders had lived through a war. They knew firsthand that when debate ends, carnage ensues. And so they wrote a Constitution not to resolve our debates, but rather to keep them going. We may lament the state of our politics in 2024. We have two sides wherein each believes that if the other comes to power, they'll destroy America from the inside out. Well, that's nothing new in American history. That's what the Federalists and Anti-Federalists believed about each other. It's certainly what Hamilton and Jefferson thought about one another. We have always disagreed about the proper relationship between citizens and between those citizens and their state. And we always will. But so long as the disagreement continues, the Constitution, in a very meaningful sense, has succeeded. We are hundreds and even thousands of years younger than other societies around the world. And yet no other country on earth has a national constitution that has been in effect longer than ours. Its longevity is an extraordinary testament to its success, not in resolving our debates, but in institutionalizing them. At the close of the convention, when Ben Franklin left the Pennsylvania State House, a woman stopped him on the street, and she referred to him as doctor. He'd got an honorary doctorate from Oxford, and she said, "Well, doctor, what have we got, a republic or a monarchy?" And Franklin famously replied, "A republic, if you can keep it." Today, more than 200 years since Franklin issued this challenge. The Constitution endures, the Republic abides, and the debate lives on. Thank you.
All right. Well, we're going to do some time for question and answer. There are a couple that just from listening and some conversations I thought we'd kind of start with, and then we'll move to whatever questions you might have. So I think we're supposed to use the microphone. All right. Well, thanks so much.
Thank you.
Appreciate it. So you had said something about our jurisprudence should be predicated on history, or if it should be, right? So one question I was thinking of is kind of broad is, what did the framers, by and large, think that they were doing, right? Meaning, what did they think that they were cementing or enabling or preventing? What did they think they were doing at the time? I know you spoke to this to some degree, but is there more you could say about that?
Sure. Well, I think certainly there was an aspiration that they could craft a document that could endure for the ages, but there was very real anxiety to think that that might not be the case. I mean, the Articles of Confederation hadn't been in effect for very long, and in fact, we sort of take this for granted, but in 1790, Patrick Henry was like, we need another constitutional convention. Okay, we had one 3 years ago, it's time for another one, right? It wasn't at all inevitable from their perspective that we would just somehow emerge from the infancy of this experiment with the longest serving constitution in the world. I think the principal fear that they were trying to address with the Constitution was the threat of anarchy. There was economic turmoil, there was political turmoil. As I mentioned, we saw in Shays' Rebellion, there was violence. And so they had to create a government potent enough to ensure its own perpetuity, a government that at the very least could provide law and order. But it's also important to note that the framers believed very fervently in the importance of individual liberty. And people Madison sort of, he changed his views here and there. But Madison, people like Hamilton, they understood that there was an internal threat about our own ability to, having opened the Pandora's box of revolutionary violence starting in 1775 with Lexington and Concord, to put the lid back on and have people sublimate their political differences into peaceful disagreements. And when you look at other revolutions around the world, the French Revolution, the Bolshevik Revolution, those degenerate into bloodshed in a way that the American Revolution doesn't. It's really extraordinary. And so I think that they were trying functionally to do two things at once: create a federal government strong enough to endure for the ages, while also ensuring that people's liberties were protected. And folks like Alexander Hamilton certainly believed that you could do both at the same time, and that energy in government, to use the term that they like to have, didn't necessarily need to come at the expense of individual freedom. If they made a mistake in the Constitutional Convention, is that they didn't realize that people would clamor for a Bill of Rights. It had been proposed by George Mason in the closing days of the convention, but it was hot and they wanted to get home and they didn't want to open up the Pandora's box of a Bill of Rights, and then everyone sees the Constitution and they're like, well, where's the Bill of Rights? And so the people reminded the framers, you all say that you care about liberty, and they all did. Well, put pen to paper, and James Madison does just that in one of his first acts as a member of Congress.
Yeah, that's really interesting. I'm thinking a little bit about some of the amendments. So I'm wondering, I know there's a smattering of questions we could ask, but one we didn't talk much about is the Second Amendment. Yeah. So would you mind sharing a little bit about kind of the history there and what some of the intention may have been? That still plays out today and has for decades about what exactly is meant and what freedoms that permits or doesn't.
Yeah, the Second Amendment is really interesting from a historical perspective. One of the striking things about the Second Amendment is that the Supreme Court doesn't rule on the meaning of the Second Amendment until 2008. And the long-standing debate heading into that famous landmark case called D.C. versus Heller was whether the Second Amendment protects an individual right to own a firearm or what's called a collective right, meaning if you're in a militia, does that mean you have the right to a firearm? And what I, as a historian, love about the Second Amendment, judges always want clarity, and historians, we love to just luxuriate in nuance, right? Is that there's actually conflicting historical evidence. So there were colonial laws on the books in places like Virginia that actually required people to carry firearms. I mean, there were safety reasons why you need to have guns on your property. And there are English antecedents that would strongly suggest that we should read the Second Amendment in the context of Anglo-legal history, which would lean in favor of an individual right to bear arms. And yet, the initial text of the Second Amendment, which gets tweaked, makes it seem as though it actually is for a militia. And so you get this really weird sentence structure. I mean, there are whole tomes written on, what a single comma in the Second Amendment, what that placement means. And what the Supreme Court rules, 5 of them say it's an individual right, and 4 of them say it's a collective right. So there's not a ton of clarity among the justices about that. What I find most interesting, perhaps, is that at the time of its ratification, there wasn't really much debate about it. And so people at the time seemed to have a shared understanding of what it meant, so much so that they didn't seem to put pen to paper as much as they did concerning some other amendments. And so we're left with this a history where there's less than total clarity about how to interpret it. And part of that is going to depend on your vantage point. And so some people who are looking at original intent are looking at the framers, but some people say, actually, what really matters is what were people saying at the ratifying conventions, because the ratifying convention is what gives an amendment legal force. And yet others adopt what they call original public meaning. How would the words be understood? And so your degree of clarity about an amendment can also vary depending on what kind of original intent you're after. And so this is exactly the kind of historical goldmine that excites people like me, but I think frustrates judges to no end.
That's that's great. There's maybe one other. I know we're kind of bouncing around, but to kind of get some good fodder here for other questions is something might be on folks' mind is impeachment clause, and again, sort of historically, what's sort of view of that when authored, and then how has that kind of come down throughout the years?
Yeah, so here again we have another great constitutional debate, and I think that there are compelling arguments for a couple different ways to think about the impeachment clauses. The 2 broad schools of thought, one suggests that it is part of the normal system of checks and balances, not that we impeach presidents or other officials all the time, that it's at the extreme end, but it is ultimately a political check on power. And the countervailing view is that no, actually it is a criminal proceeding. And the differences between those 2 perspectives are really significant, because if it's purely a political check on power, then perhaps you only need a preponderance of evidence that a sitting president has been guilty of what's been drafted in the articles of impeachment. If it's a criminal proceeding, then arguably you actually need proof beyond a reasonable doubt. And the senators couldn't decide this among themselves. And in the 1980s, the closest they got to a resolution on this was that each senator, when sitting as an impeachment court, decides for him or herself what standard of proof they're applying to the case at hand. And so it's hodgepodge. There are compelling reasons to think, when we look at the Federalist Papers, to think that it is part of the political system of checks and balances, that a president could be tossed out, simply for doing their job egregiously badly. And Hamilton says explicitly that it's political, and he puts the word political in all capital letters so that nobody misses it, right? But if we look at the text of the Constitution, there are some interesting arguments to be made that it is really more narrowly a criminal proceeding. I mean, for one, when the president is tried in an impeachment trial, the Chief Justice, the nation's foremost legal official, adjudicates the trial. And interestingly, the senators are required to take an oath. before the trial, right? They don't take an oath in any other part of the systems of checks and balances. The senators don't take an oath when they're overriding a presidential veto. They don't take an oath when they're voting down a president's nominee for the Supreme Court. But they take an oath before an impeachment trial. Well, who else takes oaths? Jurors. Jurors sitting in courts of law to render a verdict in accordance with the law and the fact. And so this second oath, this anomalous second oath in the Constitution would suggest that no, actually this is a legal proceeding, and that we shouldn't just toss out a president and invalidate the will of the people for anything other than the narrow set of criminal offenses delineated in the constitutions, which is bribery, treason, and high crimes and misdemeanors. Sometimes my students say, well, a misdemeanor, I mean, I have a misdemeanor, Dr. Porwancher. Well, it's actually, the word high describes both crimes and misdemeanors. It's high crimes and also high misdemeanors. And a high misdemeanor was a really serious offense. Like if you tried to kill the monarch back in England, that was a high misdemeanor. So I think that at base behind these two competing theories are two different philosophies. One that says we should respect the will of the people and toss out a president under only the most extreme criminal conditions, and the other that says, well, actually, the members of Congress are taking an oath not to their constituents, they take an oath to the Constitution. And if a president has been derelict in their duties to the Constitution, then they have an obligation to override the will of the people in those instances. And, I think that people of good faith can entertain good faith disagreements about how to read those clauses. And I would hope that members of the House who draw up articles of impeachment and members of the Senate who sit in the trial, in each case, think not just about the case in front of them and not just about the party, but think about the precedent that they're setting for generations to come. And in this country, we have so few precedents of impeachment trials that regardless of what the outcome is, the kinds of arguments that are going to be made will be invoked for centuries to come. And we should pay due homage to future generations as much as our own present political agenda when we think through these kinds of issues.
Yeah, maybe you answered my kind of follow-up question there, which is then, if the political record, so to speak, is could be seen multiple different ways, what is one to do, right? It sounds like someone had to make that decision on their own, which is to say, hey, sort of interpret it as you will, but that doesn't seem to be ideal. So I don't know, how ought we to think of it then, if the political record seems conflicted, what do we do about that?
Yeah, it's a good question. My own view, and this is sort of me speaking as a citizen, maybe more than a historian, is that America, if it's to be a self-governing democracy, we have to respect the will of the people. And so I am in favor of a very narrow reading of the impeachment clauses personally. Every 4 years, we have an opportunity to decide whether we want to change course, really every 2 years. And so I see the ballot box as the ultimate check on power. And so long as we have free and fair elections, I have faith in that the American people will do the right thing. There's a quote that I think is often attributed to Churchill that America will always do the right thing, but only after it's exhausted every other option. And so I think we should be very wary of invalidating the results of free and fair elections. So that's my own view. If I was in the Senate, what would I do? I like to think I'd be true to that, but you won't see my name on a ballot anytime soon. I've got too good a gig going at Scuttle, so that'll be up for great hearts and Scuttle alumni when they hopefully run for office to decide for themselves.
Great. Let's take some questions if y'all have any. I've got a whole list here, but if you would, you could come down to the microphone just so that we can get it on the recording, because especially if it's a question coming from Jay Tawney, we got to capture this for posterity.
What a great talk. Thank you so much for that. I wonder if you could reflect a little bit on the Hart versus Madison. Maybe the arguments, like the constitutional arguments for and against that decision, and maybe more importantly, because I was struck by what you said at the beginning about the not having
Yeah. This is a great question. I mean, Marbury versus Madison, arguably the single most important case in the history of our Supreme Court. This is the case where the court enshrines as a sacrosanct principle in our legal system that the judiciary is the final arbiter of constitutionality of legislation, and ultimately that extends to executive actions. That it is the role of the Supreme Court to, in Marshall's words, to say what the law is. And so the power of judicial review is not in the text of the Constitution. In fact, the term judicial review doesn't even date back to Marbury. It's not coined until the 20th century. So he's not exactly using that language. What's so interesting about Marbury versus Madison is that nobody made the argument that the legislation in question was unconstitutional, right? And there's a whole political backstory here where John Marshall's brother, who's working for the government, he has all of these sealed documents, these commissions to appoint different judges and justices of the peace and the like that John Adams was issuing even at midnight before his last day in office. That's why they're called the midnight judges. And Marshall's brother literally can't carry all of these commissions because there's so many of them. He can only hold so many in his arms. And so he leaves some behind in the State Department. And then Jefferson gets sworn into office. And he actually finds in the State Department these commissions sitting on a table. And he says to the new Secretary of State, James Madison, he says, don't deliver those, right? And so there's this key question in Marbury v. Madison. Is the Secretary of State legally obliged to deliver this commission to this guy, William Marbury, who was a Federalist, right? Jefferson's a Republican. And so this whole debate turned on this fundamental question of whether once a president has signed a commission for a judge or a justice of the peace, and it has the seal of the United States fixed on it, is the physical delivery of that commission purely what's called a ministerial duty? Is it a non-discretionary legal obligation incumbent on the Secretary of State? Or is it part of the discretionary power of somebody working in their capacity as an advisor to the president, right? Because people working in the executive branch, they're wearing both hats. And nobody, the Jefferson administration actually didn't even send anybody to argue it at the Supreme Court. That's how little Jefferson thought of the case. And Marshall, when he hears the case, he calls out to the court, does anyone want to argue on Marbury's side? And nobody did. But there's no record of anybody doubting the constitutionality of the legislation. And Marshall invents this issue and claims that the judicial act passed by Congress that enabled the president to create these judgeships was itself unconstitutional. And so he hands a major win to, even though Marshall's a Federalist, he hands a major win to Jefferson and the Republicans by saying, actually, because this legislation is unconstitutional, the commission doesn't have to be delivered. But on the other side, he's vastly expanded the power of the judiciary, in a sense, by establishing that the court has the power to invalidate congressional statutes. And so Marshall, if we think of him as a kind of chess player, it is an absolutely brilliant move, right? Because he expands the power of the court, but by ruling in favor of Jefferson, he doesn't give Jefferson anything to fight against, to agitate against, right? And so he protects the court from a popular president who has the backing of a Republican Congress. And as a question of constitutional law, does he get it right? I mean, it's taken as an article of faith that he does today. There have been some critics of Marbury v. Madison throughout history, and actually the last book I wrote was on a little-known 19th century legal scholar who was one of the only people willing to criticize Marshall for this opinion. And basically the feeling there, and this ties back to our discussion about impeachment, is that the people are sovereign in America and they speak through their elected representatives. And if the courts come in and say, well, we're going to decide what's constitutional and what isn't, then that has an enervating effect on our democracy. It incentivizes legislators to not really think about the constitutionality of their legislation, thinking, oh, well, the courts will set that right if there's a problem. And it incentivizes people to look to the courts to resolve our issues for us, instead of doing the hard work of winning over hearts and minds during election season. And so the argument that's made is that it is ultimately to the ballot box that we should look to remedy our problems. Legislators are going to make mistakes. They're going to pass bad laws. It's inevitable. But when the legislature passes bad laws, we can vote new people in and fix that. When the judiciary invalidates legislation, that's harder for the voters to rectify immediately. And so again, I think that it comes down to this question, and here people of good faith can disagree, about how direct do you want our democracy to be? And there are smart and thoughtful people who think that our institutions should be a sort of mediation between the people and our constitutional principles. And not everything should be left to the will of the voters without guardrails. And so again, here I think people can of good faith can come down differently on this question. So anyway, I've been talking for a while, but only because it's such a rich historical case, and Jefferson actually had a history with John Marshall's mother-in-law. And if there's any students in the audience, take a class with me at Skettle. You'll hear all about it. You won't hear about it in law school, though.
Other questions?
Thank you for a wonderful talk. And you made a very open-ended and intriguing statement that the Constitution keeps us talking. How far I'm really interested to hear you expand that, and how might we apply that to other situations besides merely the
I'm sorry, the last part of that question is, how do we apply that to what?
Or I'll ask it this way. Other organizations have applied those same sorts of principles themselves.
Yeah, it's a good question. Not every, and thank you for that, not every organization needs to be a democracy, right? It might make sense. Some of my friends have gone off to Silicon Valley, and I think that they would probably say that they don't want a system of democratic governance across their company where the CEO's voice counts as much as a summer intern. And fair enough. And they exist to make profits rather than to be representative. At a university, academic departments have a lot to say about democratic governance within university departments. Deans, and provosts, if they were honest, might say something a little bit different, I can say that because I'm tenured. So you should have heard the version of this talk before my tenure, though, much less candid. So I think it's an interesting question. Americans, I think are sometimes criticized for civic apathy. I think that we actually are pretty civic-minded people in a lot of ways. One of the things historians have written about is how Americans had the rise of all of these voluntary associations in the early republic, and they would draft constitutions for themselves. Often you have religious houses of worship after the Constitution is ratified, drafting new charters for their houses of worship that are modeled after the U.S. Constitution, including bills of rights. And so we are, I think, a democratically minded people. And so I think that it's great if we can look for opportunities at a local level, because most of us aren't going to serve in Congress, and do want to have a voice in our system. So I don't know if I've fulsomely answered your question, but it's unanswered a question.
Then you expand on how it keeps us talking.
Oh, how the Constitution keeps us talking.
Right,
Yeah, so I think that there are a few different ways. First and foremost, the protection of freedom of speech, right? We have far more robust speech freedoms than many other countries. And that's not just true of some autocratic regimes that crack down on speech. There are things that you can say in this country that would get you arrested in Europe, right? Things like Holocaust denial. And I think Holocaust denial is abhorrent, but our freedom of speech is premised on the idea that when you have an idea that you think is wrong, the answer isn't less speech, it's more. The answer isn't to shunt those people to the shadows where those ideas can grow and metastasize in the dark and become a covert threat. It's to get them out into the open where ideas that we think are wrongheaded can be addressed fully and debunked as erroneous. Or if I'm wrong, then my ideas will get debunked. And so I think that the First Amendment is even though it was in the third, the free speech was in the third. Now it's in the first, and rightly so, because I think that is the most essential to keeping our debates going. And then I think the second is, as I alluded to before, free and fair elections. When people have recourse at the ballot box, most people will not resort to violence as their first order of business, right? And so it's essential that, one, we have free and fair elections, and two, that people believe that those elections are free and fair. And so I think if we continue to do those two things, we can resolve, or at least keep going all of our other challenges through open and unfettered debate. And so, I'm personally in favor of a pretty expansive vision of freedom of speech in the First Amendment, precisely because of this question of how do we keep these debates going. And then at the level of government, Congress, we have a speech and debate clause in the Constitution that a member of Congress can't be arrested for things that they say in Congress, right? That's literally keeping our debate going. You can't have a president arrest members of Congress and prevent them from having a quorum for, say, casting an impeachment vote against the president. And so the framers were really savvy about this. And they knew that America was a large, diverse, and fractious nation, right? They knew that it could be at risk of becoming factionalized, which it certainly did. And so they created guardrails in the structure of our government to ensure that factional fighting could be done peacefully. And of course, we see the ultimate breakdown of that in the Civil War. And what Lincoln understood is that winning the Civil War wasn't just about keeping the Union together. It was about the preservation of the very idea of self-government. And that we had to win the war to prove that the only real recourse is through open debate. And everyone knows Lincoln's second inaugural address because it's so poetic, and it beautifully weaves in poetry and biblical verses. But if you read his first inaugural address, which I encourage you to, it is a very legalistic but very persuasive argument about why taking up arms when you're in the minority is ultimately an untenable political philosophy. So thank you for those questions.
We'll do one more, Ms. Van Brent, and then we'll be able to continue at a reception later.
Okay, thank you very much. I just have a question about, you speak of the will of the people through the vote, and I'm curious about the historical context in the minds of the framers for only giving the direct election of the members of the House of Representatives. That there's the state legislatures or Senate, electoral college, etc. I'm curious about the background of that, and also your perspective on the necessity or relevance of the electoral college today.
Yeah, thank you. Thank you for both of those questions. And also, this is unrelated, but I meant to say in my talk, he mentioned I'm the director of graduate studies at Skedel, and we have a lot of Great Hearts teachers who take our degree part-time. And if there's any teachers in the audience who are interested in a fully funded master's degree, where you can talk about this stuff with me all the time, come chat with me afterwards. I'm happy to talk to you folks. Okay, so the question. So there's the question about the Electoral College, and then there you are. And what? Sorry, what was the first one?
About the House was directly elected.
Oh yeah.
It seemed that there was an intentional, that there was some intentionality by the framers to have that separation of the legislatures for the Senate, for example.
Yeah, that's right. So initially, for much of American history, into the 20th century, the state legislatures were picking their senators for the U.S. Senate. And in fact, if you go back early enough in American history, electoral votes weren't always distributed by popular vote. And so and I'm glad you asked about the Electoral College and the Senate, because in a way they're sort of different variants of the same question. The framers did not believe in mass democracy in the way that we understand it today, right? There was a fear of oligarchy, there was a fear of aristocracy, but there was also a fear of mob rule. And so the Constitution that they create is a kind of mediation between those two things. And so you have on the one hand the House, which is going to be highly responsive to the needs of the people. They're directly elected, they're voted every 2 years. And then the Senate is in a sense 2 steps removed, because not only are they chosen by the states, not by the people, but senators are elected only every 6 years. And so the House is designed to ensure that the government remains highly responsive to the needs of the people, but the Senate is designed to be a check on the transient whims of the people, right? To be this is an original phrasing, but to be the kind of cool basin that cools down the hot water of the House. And so the aspiration of the founders as well in the Electoral College is to have a check on the people. Yes, the people are going to have a voice. Most states pretty early, in the early years of the Republic, moved to a popular mode of choosing delegates to the Electoral College, right? But it's not a direct election, right? And so you get certain states that are getting more representation proportionally, even though as it's generally proportionate. And so over time, we have moved in the direction of, towards mass democracy. And we moved through a constitutional amendment to direct election of senators, which is actually, when I started studying constitutional history, became a professor, I didn't realize when I gave public lectures how often people would raise this question about direct election of senators. But I found all over the country, people really care deeply about this issue about whether the states are represented in the Senate or not. And again, I think this is another issue where people of good faith can disagree. But I think it's important to understand that what the framers were trying to achieve, at least if we take them at their own words, was a kind of aristocracy of virtue and talent, where you don't have mob rule, you have a leadership selected among the very best people based on their talent, not based on their birthright. And by the way, the Anti-Federalists, they didn't like the idea of a Senate, right? They thought, well, that's like a House of Lords, right? And they didn't like the idea of a president. They're like, well, that's going to be like a king. And Hamilton stupidly wanted to call the president an executive monarch. And I'm a Hamilton biographer. I love Hamilton, but he didn't show the keenest insight into PR in that moment. So I think that you have this desire to have a certain kind of check on the people, to have them with enough of a stake that they can respect the government as being premised on the consent of the governed, but not being wholly beholden to the vicissitudes of public opinion as it sways in the wind. So thank you for both of those questions. Those are both really good. And sometimes when you get a question and the answer is some version of people of good faith can disagree, you know it's a good question because it means I have a really unsatisfying answer. But such is my lot to be a historian rather than a law professor. I don't have to resolve any of these issues. I can just sort of marinate in them. So thank you for that question.
That's wonderful. All right, we'll wrap the questions there for now, but we'll have Professor McNamara, Dr. McNamara, Carol, known by many titles, come up and close us.
I just want to say that I think that when the United States Congress created Constitution Day, they probably envisioned an event and a discussion just like this one. So I want to thank our speaker and our moderator. And I also want to encourage you to speak to Professor Porwancher about about the undergraduate program at the School of Civic and Economic Thought and Leadership, as well as the fully funded master's program. Please also join me in thanking all the people who made this event possible. Annie Mitsuda and the Institute team, Shannon Richards and her communications team, and the Jack Miller Center and Veritas Prep and Archway schools. So thank you very much, and please join us at the reception in the library. Thank you for coming, and thank you to all of you for taking an hour from, or a little more than an hour from your evening to join